Hi friends, this is Bindu Sharma from Origin. Purpose of this series of videos, Key Terms Patent Act, is to understand important terms used in patent law. Term to be discussed today is lapsed patent under section 60, 61, 62 of the Act, and it is described in chapter 11. Lapsed patent is the one for which patentee has not paid renewal fee, and such lapsed patent can be restored. Lapsed patent should not be confused with expired patent, and the difference is that lapsed patent has a chance of restoration, whereas the expired patent does not have a chance of restoration. Let's have a look at entire procedure of restoration of a lapsed patent. Failure to pay renewal fee results in lapse of patent. Request for restoration may be filed if the applicant wants patent to be restored. If the controller decides to restore the patent, such restoration is followed by publication. Restoration of a patent may be opposed. However, the controller takes final decision with respect to restoration of patent and publishes it. Let's see this illustration. The due date for payment of renewal fee is 24th June 2009. And the applicant fails to pay renewal fee. As a result, the patent lapses and ceases to be in force. If the applicant wants to restore the patent, he shall make request to restore the patent before 24th December 2010, that is within 18 months from the date patent ceases to be in force. An application for restoration of seized patent shall be accompanied by a statement explaining circumstances and the reasons which led to failure of the renewal fee payment. Controller may ask applicant to produce further evidences in support of circumstances or reasons provided by the applicant. Section 61, Procedure for disposal of applications for restoration of lapsed patent, says that once the applicant makes request for restoration of his patent, along with the circumstances because of which he could not pay the fees, the controller shall be satisfied that failure to pay fees was unintentional and there was no undue delay in making the application for restoration. After hearing the applicant, if the controller is prima facie satisfied that the failure to pay renewal fee was unintentional and that there has been no undue delay in making of application, he shall publish the application. Any person interested may give notice to the controller of opposition on the ground that the failure to pay renewal fee by the applicant was not unintentional or there has been undue delay in making of the application. Controller shall give applicant and to the opponent an opportunity to be heard before he decides the case. If no notice of opposition is given, controller shall, upon payment of unpaid renewal fee and the additional fee, restore the lapsed patent. Section 62, Rights of patentees of lapsed patents which have been restored, explains that failure to pay renewal fee may lead to lapse of the patent. The time between lapse of patent and date of restoration of a patent by the applicant is very crucial, and during this time there is no protection available to the patent in legal sense. During this time, someone may commercialize or use the patented invention assuming that the patent has ceased to be in force. In such a case, if anyone has started commercializing the invention and then applicant restores the application and patent comes into force again, the situation is extremely sensitive. To protect the persons who have begun to use the applicant's invention between the date when patent ceased to have effect and the date of publication of application for restoration, every order for restoration should include the provision, and the controller may impose other conditions for protection and compensation of the persons who have begun to use the applicant's invention. Here it is interesting to note that no suit or other proceeding shall be commenced or prosecuted in respect of an infringement of a patent committed between the date on which patent ceased to have an effect and the date of publication of the application for restoration of the patent. As per Rule 84, Restoration of Patents, upon receiving the request for restoration of patent, the controller shall be satisfied with the statement of the applicant that delay in payment of renewal fee was unintentional. If the controller is satisfied, he may restore the patent and intimate the applicant. Application for restoration of a patent shall be made in Form 15 along with the fees of 2,400 rupees for natural person or a startup, 6,000 rupees for small entity and 12,000 rupees for others except small entity for e-filing, 10% additional respectively in case of filing by physical mode. Application for restoration of a patent shall be made anytime within 18 months from the date of lapse. Rule 85, Opposition to restoration under Section 61 says that after the application has been restored and such decision is published, any interested person may oppose the decision of controller. Controller shall send a copy of notice of opposition to the applicant. According to Rule 86, payment of unpaid renewal fee, if the controller's decision regarding restoration of patent is in favor of applicant, the applicant shall pay pending fees and restore the patent. If the controller decides in favor of the applicant shall pay unpaid renewal fee and the additional fees as specified in the first schedule within a month from the date of order of the controller allowing the application for restoration, and controller shall publish his decision. Now it's time for the question, and question for the day is: for the restoration of lapsed patent, the payment of pending renewal fee should be made within 6 months or 9 months or 18 months or 24 months from the date on which the patent ceased to have effect. You can put your answers in comment section below. Thank you for watching this video. For any queries related to our services, you can contact us. Email ID and phone number is given in the video description. See you next week. Till then, keep learning and keep innovating.